Hey guys, we're back to you today with In Your Best Interest. I'm Justin Sisemore. We got, as usual, Mary Maloney and Andrea Jones. We're going to talk to you today about settling divorces outside of court, really the meat and potatoes of what we do, and the different alternatives there. So, Mary, why don't you kick us off?
Well, I'd say first of all, it's a lot of people don't realize that that's even a possibility, right? So, and being that most family law cases are settled out of court, can you kind of start out by explaining what that means in general? Because there's different types of things that you can do, but just maybe a broad overview of what that means to settle out of court and not just go hash it out in front of the judge.
We actually brought some valuable merchandise, i.e. the family code today.
Can we read through
I
that?
mean, I could just read it to you guys.
It is fascinating.
So mainly the things we need to think about when we're talking about alternative dispute resolution is the terminology that lawyers have created. I call it just getting it done without going to court or settling. So we have really 3 to 4 main vehicles that we use. One is what we call arbitration, which is kind of privatizing the courthouse, meaning that you've got an arbitrator that can actually come up with binding decisions. We also have mediation, which if the parties agree, and usually they're in separate rooms, you got a mediator bouncing back and forth. They'll come up with binding and irrevocable agreements. And if approved by the court, which 9.9 times out of 10, the courts will approve. You also have informal settlement conferences, which basically that's that part in the family code, that's 6.604. And I'll kind of break that down in just a minute in the family code on informal settlement conferences and the do's and don'ts with that. And we also have Rule 11 agreements and just agreements between the parties, right? So some of those are kind of thrown into 6.604, which is the settlement conferences or informal settlement conferences, but there's actually terminology that's really important there.
Okay, so let's kind of take a deeper dive into some of those different types of alternative dispute resolutions. The first one being mediation, and I think it's interesting because in different states, mediation is approached differently, or even in different counties in Texas. So what does mediation mean for parties to a family law dispute in Texas?
Yes, I think there's this like wild conundrum that we're either going to be really amicable or we're just going to be at war with each other at all times. And the reality is we're really trying to get the dispute resolved. Family lawyers that are good are covered up with business, both since COVID, before COVID, and post-COVID, certainly. So, the ability to be able to get something done without waiting a year or two to get to trial in some cases is always beneficial for several reasons. Number one, in mediation, you can't wake up the next day and have buyer's remorse. When you sign that dotted line, you're stuck. And what I do hear people say sometimes as well, I couldn't afford litigation, so my attorney forced me into the mediated settlement agreement. You got to really remember, and everyone needs to know, mediation is signed by the parties and is irrevocable because all of those prerequisites, I'm not being forced, you're not coerced, you're not under duress, you're not drunk, you're not on drugs. And that's actually in the mediated settlement agreement in big, bold letters. And so the good mediators are very good about the warnings that happen. And so sometimes what happens is somebody wakes up the next day and they're like, well, I felt pressured at the 11th hour. So mediation is the tool or vehicle that we use probably, I would say, 90% of the time. And of the 90%, 90 to 95% of the cases settle. So it's a great tool to be able to lock in and not revoke what the agreements are. You sit down in one place. You're with your lawyer all day. You can talk through different scenarios. You can get evidence ready. It's just a very good place to control the outcome of the case.
And isn't that ordered by court too? Because you shared that before. It's ordered by the court to do it.
So,
right?
so most courts will actually have what's called a pretrial scheduling order, which basically dictates our timelines or our KPIs or key performance indicators of like how well the case is tracking. And I know clients. I had a client yesterday who was like, "Well, it's been 7 or 8 weeks, and there was this lag time." And I know 7 or 8 weeks feels like an eternity. 7 or 8 days, 7 or 8 minutes in a family law case, but in court time or in lawyer time, because you have these gap periods, it's really not that far out. And keep in mind, you're trying to get your inventory, all the backup documents, because you're going to get to mediation sometimes, and they're like, well, I don't believe your numbers. So you've really got to kind of get the case ready like you're going to trial. But in civil litigation cases where, and I know divorce and family law is civil litigation, but in real civil cases, big civil cases, you're actually kind of presenting certainly opening statements and whatnot like you would be adversarial in trial. We don't do that very often in family law, but some courts and some states, like Colorado, for example, they mandate mediation before you can set a hearing unless there's any family violence or emergency situations. So the courts are very much in understanding that even if you think you can't reach an agreement, we're going to try to make you do it. And most of the time people get surprised by the bend factor of the other side, even if there's a lot of emotion.
So for somebody who has never been through divorce, and hopefully many people don't have, but if you have to do it, so what does it look like? What does it look like? I go to a different place, I do it at my lawyer's office. What does it look like, mediation?
It really does depend on the logistics of the parties. I see lawyers try to posture sometimes where it's like, oh, we're mediating in their office, so we're giving up ground. And usually it's no, you just have more space
Right.
or available space. Like, we're really trying to save costs. Our building, we're lucky and fortunate to have 2 conference rooms that are on opposite sides of the building. You're not crossing ways going to bathrooms and all that stuff. So, it's important because even when you exit the building, for example, there's still fear there. There's still angst. There's still emotion. So it's nice to really think through that. And, lawyers that we've worked with in the past, they know that there's no advantage to being in my building or theirs. And a lot of mediators are, former judges or former lawyers. They don't have fixed facilities anymore. So it doesn't make a lot of sense to go and pay for a fixed facility if we have one free of charge, in my opinion. But that sense of comfort, like our other conference room where the other side would go in, it doesn't have my picture and all the stuff on the wall about how great I am. Like I go
Does the other one have your
hell
picture?
yeah. And it's like, I walk in there and it's like a shrine of somebody. I'm like, man, that makes my client feel great that we're staring at that for 8 hours, right? So I'm very careful to a degree on which rooms we'll enter. And then things like bathrooms, how thick the walls are. I mean, I'm thinking about all this because that may be the last time I actually have face-to-face or my team has face-to-face interaction with the client, and I want them to feel comfortable. Do they have good snacks?
Yeah, good. So I go into one room with my attorney, and then the opposing side goes into another room, and then the mediator goes in between, or how does it work?
Yeah, so I mean, the formal way we do it in family law is probably a little bit typical of most cases, but I don't like to see parties go in the same room and stir up the emotion in the first 5 minutes. I don't think it's very helpful, and oftentimes there's a lot of emotion just by the physical sight because, by the time you get to mediation, they may not have seen each other for 4, 5, 6 months sometimes. So that just one first visibility can stir up all the emotion. So we try to stay separate. I think the good mediators are very cautious of that, and they definitely understand it. And the mediator will ping back and forth. And so the petitioner or the person that brings the lawsuit is usually the person that starts in on the negotiations as far as the offer. And oftentimes we, as the petitioner or movement, have floated an offer already across the bow. And so we're kind of like, well, we're not going to keep doing it. We're not going to negotiate against ourselves. We want to see what they're after and what their issues are. So the first couple, runs of that, you're going to get what I call the dry run, the terrible offers and all that stuff. And so I just tell people, hey, just be patient, just listen, just hear this stuff for a minute. Don't get mad, don't get up, don't get angry. Now, if we're getting the runaround or that monkey business, I will pack my stuff up and jolt out of there with the client as quickly as they want to. If it's just off the wall stuff and we're not getting anywhere or somebody's not even coming prepared, I mean, I'm not going to waste a client's time and money on that.
Right. For sure. So just kind of a recap quickly on mediation. I just want to, in Texas, a lot of times the judges will order mediation. And also most of your cases do settle in mediation, correct? Right?
That's correct. Yeah, probably. I would say, I always tell people 90 to 95, but it's maybe even more than that. The child custody cases where you can't saw a child in half, or the business valuations where, there's a differential of the house value between the parties because one party knows they're going to have to write the other party a check, and they don't sell the house per se, or one party doesn't have the financing ability. Those are where you see limited issue mediations happening, to where sometimes you can resolve part of it and not all of it, but you're still trying the process.
And the benefit, the way I understood it, the benefit in the mediation is I have a mediator that really knows the case by the time you get there, or learns the case there and sees the differences. And really, you said a whole day So I have a whole day where the parties can negotiate. So everything is on the table compared to a judge who might only listen to you for an hour or 2 hours and then make a decision and maybe never read the whole file or has all the information. So is it better? That's why it settles, because it's a better solution?
Well, to say that mediators are fully apprised of all of the facts in the case is probably a bit of an overstretch there. And that really depends on how much the lawyers on the front end are giving information to the mediator. What I try to do, especially in a property case, is get everything really organized and to where we can easily disseminate the information, transfer it to files, and send it across the bow. And then, like I say, I'm a big spreadsheet guy. So if you have a 35-page inventory, I want to see it on 1 or 2 pages. And when we start to move items, I can do that via computer, but I'm a very visual learner. I like to have the documents printed out in front of me and not be staring at a computer screen. So the mediators themselves, what we got to remember is a lot of them are former judges, okay? So, they know how I've been in front of them in a courtroom. They know they feed off emotion, and if, sometimes if a mediator is really trying to push an agenda, it can be to your clients like big time surprise. I mean, there's some forceful mediators out there that were former judges, and they'll be very firm and stern. And the client's like, wait a minute, I'm paying for this to be a peaceful process. And sometimes mediators have different styles, or not sometimes, all the time. And so you got to really know that going in. And I think prepping the client for just, hey, this is a tough judge. They're going to say some things that their delivery may be off. Don't take it personal. But do understand when they're pushing you in an issue, they're trying to get you to a space of agreement because they know what that other side is going to do or say, and they're not allowed to share that across the different rooms unless you consent to it. So stylistically, we really do think about the mediator themselves for sure.
Okay. Well, let's hop on over to Rule 11 agreements. We talked about this extensively just the other day. And a lot of people, like Andrea, you said a lot of people call and ask about it. You obviously deal with that all the time. You know what Rule 11 agreements are, but the average person isn't going to. So we kind of want to talk about what those are and as it pertains to for family law and how they're used.
Okay. So Rule 11 agreements are enumerated by the Texas Rules of Civil Procedure, Rule 11. It's basically just a formal procedural element that allows lawyers to come up with agreements. It can be something as simple as you're going to pay for the air conditioner bill, or the injunction says you can't go buy a car, but we're going to make a Rule 11 agreement that says you can. So, I use the word CYA, but really what it is covering your basis to make sure that, if clients, I know this is hard to believe, but sometimes clients don't remember their agreements, and sometimes they just don't honor them, and sometimes they just go against what they were going to do, and there's not a meeting of the minds. So Rule 11 agreements are a vehicle to really get everything down in paper that you're orally negotiating, and then they can be enforceable just like orders, okay? The challenges, and you haven't asked that question yet, but the challenges of Rule 11 agreements, and one of the things that I get frustrated with a lot in my business is that Rule 11 agreements in civil litigation and other areas of civil litigation are very, very strictly construed by other courts. In family courts, because we have child custody provisions that are required by the court to be approved by the court and required by the code to be approved by the court, there can be revocations, or you can revoke your agreement up until the entry of the order. Now, just because you can, the family code says you can, doesn't mean, in my mind, that the court shouldn't say, you spent a bunch of money to get these agreements, you worked through this, you spent attorney's fees, you worked through the headache, but we're just going to say because this case said you could and you've revoked it at the 11th hour, now it's fine, right? That's where I get really frustrated. Same for motions for new trial and various other elements like that.
So but again, the Rule 11 happens, so I start the divorce, I have temporary orders, and then the Rule 11 basically is a way to not honor, but to make different changes. So for example, if you're ordered that you cannot touch the investment accounts, but you need money, the Rule 11 would say, we both agree that you can take money out there to buy a car or something. That's so it's the second step. So there's an order in place, a temporary order, and then the lawyers agree to do certain things that are actually, according to order, not allowed to do.
Yes and no. So the Rule 11 agreement can actually be the underlying document that gets you to a temporary order, or it can be you have a temporary order and you're making agreements outside of that or in addition to,
So
or that contradict the order. So you can use it both ways. But again, I've had cases where the clients are like, "Why am I paying to do the order? I've already got this a Rule 11 agreement." And my answer is because they can revoke it until it's a valid order. And you can still modify an order, you can still file to go do that, but then the burden of proof changes, right? You got to show that the orders are unworkable. Well, that's a different standard than, hey, we tried that, or we haven't put anything into writing yet into order. So I like to get them reduced to orders, or I like to have mediated settlement agreements if we're dealing with or disposing of final issues. But even in temporary, I mean, some of my cases have $20,000 and $30,000 a month coming in spousal support, and so and you're paying all these expenses, and we're going and running businesses and acquiring assets. So I want to make sure that those Rule 11 agreements are binding and enforceable, and you're not just going to wake up tomorrow because you have kids attached and you found this little case that says you can revoke it at any time. So taking that extra step is sometimes necessary.
Right. And I think you were saying too the other day that it's really important that when you're writing, the attorney is writing those agreements, that they make them as, I guess, unrevocable as possible, right? I mean,
Yeah, I mean, I don't know how many more times we need to write this agreement as binding and not subject to revocation. We put it in big, bold, all caps. I mean, the family code has a bunch of this language that needs to be in there. The challenge, of course, is when you have kids, the court approves it. So, to me, the property stuff should be binding, and you should have enforceability. And I'm not saying that at all times they'll never enforce it if you revoke it. But what I see most often is somebody gets frustrated right before trial, and they go, "All right, well, I'm just taking all my deal off the table." And so that's where I'm like, no, we're going to pop a mediator in here real quick. We're going to pay them a couple $100 and they're going to sign it. And you're not going to do that to our client if that's happening, right?
Are there any other, just briefly, can you give some examples of Rule 11 agreements that are kind of common?
Sure. Discovery extensions. So you've got a discovery deadline. You've got an agreement that, maybe you've got 30 days to respond, but you're going to extend the timetable to respond. And again, that's providing the paper trail so that when the other side says, "Well, I didn't agree to that. My attorney didn't know that. They didn't talk to me about it." Attorneys can use Rule 11 agreements to make deals. And I want to be clear, part of the reason you hire an attorney is to make a deal on your behalf because there's emotion involved. And you might trip over your own shoes a little bit. So if opposing counsel, this happened to me last week, my dad died, okay? And I've got people, "Well, I need the discovery today." Well, I'm not excited about going into court and letting them know what a jerk somebody was, but I absolutely will. And the Rule 11 agreement was just, hey, listen, his dad passed, he's got a funeral. I can't get to answering all this stuff today. Would you extend it? No. Well, we're going to have some fun now, right? And that's when you really awaken that sleeping giant. And if you're the client that really wants to just go, I'm going to say balls to the wall on everything. If you're that client, remember that your lawyer's job is to take some of the emotion out of it and think like the court will think. And so you got to really try to use these avenues to solve the problem. I mean, the black robe doesn't want to see you in there all day long, every day over every issue, and they're not going to come through with a scalpel. So we can come through as attorneys with a scalpel instead of a meat cleaver and carve out some specific details that matter.
Common sense, right? I mean, somebody's
yeah.
in a hospital and they can't deliver the stuff, then it's a normal thing to say, "Hey, we give them a little bit longer time to do."
Yep. And then things like, refinancing the house, selling property, allowing somebody to go and take a loan out, buying an asset, moving a key member out of a company. Those are all things that I like to just have a paper trail. And even with a client, I like to memorialize our conversation because, 8 months later, when you're mad about something else that was out of our control, and you say, "Well, y'all haven't done anything for me," right? And that's very rare, but it does happen when people get that mindset. And I like to be able to go back to all the emails. And, I had a conversation 2 days ago on this very issue with a client, and they were very, very upset. And I believe me, I'm the first to admit when we make a mistake, we try to make it right. But there's some things that we just didn't do. And sometimes it just gets distorted or confused. And so for me, having that paper trail and a Rule 11 is a great example of that. Doesn't make me say, "Hey, I'm right and you're wrong and you're an idiot and your perception's wrong," but it lets me say, "Hey, this is why we did this and this is how we did this," and it provides that paper trail to let the client sometimes see, okay, maybe I was a little caught up in something else.
Okay. So there are different types of settlement agreements that do come into play, informal settlement agreements or revocable settlement agreements. and those can occur at different stages in the legal process. So can you kind of touch on some of the other key ones that would happen in a family law case?
Yeah, so when I talked about the mediated settlement agreement, you can create binding and irrevocable informal settlement agreements. The parties can do it. The family code actually says the parties to a suit for dissolution of marriage may agree to one or more informal settlement conferences and may agree that the settlement conference may be conducted with or without the presence of the parties or attorneys, if any. Okay? So if I'm a paying client and I'm going, wait a minute, I can do a deal, okay? That seems really nice at first glance because you're tired of paying lawyers. You don't want the lawyers involved in it. You think they're muddying the water, whatever's going through your head. And if those are the case, I'd highly encourage you to sit down with your lawyer and try to just kind of hammer that out and get out of the relationship if you don't feel like you're getting that treatment or if you feel like you're getting the incorrect treatment. But when it comes to parties reaching deals, I love when parties reach a deal. It's awesome. I mean, I've had cases where there's $40 million and the client spends $2,500 or $3,500 on the case. Well, why wouldn't you want to do more work? Well, we have 300 people that will fight about the weather, right? I say that all the time, but for real. And so if we can utilize our team members to just help paper up the deal, that's way better than having to listen to people scream about whatever's going on and the hardships that they may face. And you know that they're getting the deal they want. Now, what I don't like is when somebody pushes somebody into a deal, manipulates them, has been manipulating them for years, and they say, you need to take this or else I'm going to do this, that gun barrel to your head, right? So what I tell people is, that's fine, take a breath. Let's take a minute. I don't like to ever see a party feeling like they need to do a deal without their attorney present. It's just bad business. I love the fact that when you have no assets and no kids, and I very much appreciate the idea of being able to do things yourself, but there are so many intricacies that are involved in these cases. When you try that, you really get into a tough situation quickly.
And you shared that before. Sometimes you do it yourself, or you think you do it yourself, and it's not enforceable. Meaning, if there's something wrong in there, I can't go back, and I can't force the other party to actually do it or do an enforcement. So it's important.
Well, that's why I brought up that you can do it with or without your attorneys. All the time I get, hey, we've reached a deal, we're ready to do this deal. I'm like, okay, well, we don't have a sworn inventory, we don't have discovery. I can't sign my name to a deal without sworn inventory. Unless it's very, very different circumstances. Because if you miss something and you put that all-encompassing language in there about they keep their bank accounts, they keep their credit card statements and all that, you've divided the assets. So these informal settlement conferences, all the time when I get them back, most of the time, they're, hey, did you think about this? What are we going to do about this? Well, I don't know. We didn't talk about that. I'm not trying to stir the pot, but there's still stuff to resolve.
Right.
And you said before, a divorce, once the divorce decree is final, you can't go back and just change it, right? It's not that easy to say like, oh, once the divorce decree is entered, so I make the agreement, it's entered by the court, then it's final. I can't go back and say, oops, unless it was fraud or intentional.
Yeah, I mean, undoing a divorce decree is very challenging. There's actually provisions in the family code that, if you sign to agreement as to form and substance, what that means as far as your right to appeal, and we could go on for days about that. But the idea there is that, let's say you want to change something with respect to property. Well, there's a period of time, it's called plenary power, and if the court loses plenary power, you can't go back. They can't go back and substantively change the agreements or the decree. Okay, they can go back and make clerical corrections, and they can enforce the decree, but making changes post plenary power is not within the court's discretion or purview, so they can't do it.
And we had people call and said, hey, I have a divorce decree and I want to change it. And that is not that easy unless
the cabin 2 months ago sat on two pieces of lot, and it just said, you're awarded the cabin. This was a $2 million property, and the parties just, well, we're going to do this ourselves because we don't want to spend $10,000, and I get it. Believe me, if I can save $1, I'll save $1. But we're halfway through that, and we've just now got the parcels of land bifurcated into two separate parcels. Then we go decide who gets what. So, I mean, it's like, what did you save there? And you don't have jurisdiction over the people or the property. Mm-hmm. So it's harder, right?
Well, my final question here kind of dovetails into that because we really want to talk about why it's important to get legal advice when you are going through a family law matter and you want to settle it out of court. Like you said, people can DIY perhaps, you know?
Yeah.
But it's really usually a very good idea to get legal advice. Can you kind of explain that?
Yeah, there's so many resources out there that I really love the fact that we're using AI and we're using Google tools and we're, Google a petition right now. Go Google a petition, go Google a counter petition, go Google an answer, go Google a divorce decree. You can pull all that stuff and see much of the content. And the work product, in my mind, is some of that. That's a very, very small fraction of what we do. Most of what we do is the behind the scenes to back up and verify values and amounts and horse trade within accounts of what's really best for the client. So they say just and right division. We're not allowed to say fair, but it's just and right division of the marital assets. So if you've got, let's say wife is non-breadwinner and husband was the breadwinner for all these years, and he's got this business and all there is one house, that she can't afford. And it's a multi-million-dollar house, and he's going to go on with this business that he started with his parents before they got married. Or he's a doctor and he makes $1 million a year, and she's been a stay-at-home and taking care of the family. And I'm not using men and women there; we can interchange those. But those situations create a significant imbalance of one party's ability to navigate the financial waters post-divorce. So that's the stuff, that's the meat and potatoes of what I'm looking for when I'm doing these divisions. And in mediation, unlike in a courtroom, where I'm just chopping it up, I can go, hey, you do this, but we want, potentially contractual alimony over here. We want some maintenance claims over here. We want to balance the tax burden here. I can do those things that are not even in the confines of the purview of the court. And that's where the informal settlement conferences really, you get the bang for your buck.
Man, look how big this book is. There's a reason you guys go to law school for a long time. It's like same thing, you Google what kind of illness.
Well, this is
you might
just
have
one of them too. This is just the plus.
There's one, yeah.
Plus and
Because I always
plus
laugh
minus and then civil procedure and all.
Correct. Because I look at laugh when people do like, I'm going to go to Google and see what illness I have. It's the same thing. I mean, good luck. You can try to figure it out, but maybe you need to go to a doctor and do that. And the same thing with lawyers. You need to kind of get the advice and not to do it yourself, even though it seems appealing. But
this lady that hired me yesterday, and she's super cool, goes into court and she's like, hey, I didn't want to bring all this stuff up about my husband. He had a lawyer. He got primary. This dude has 3 DWIs. He has guns in his house. And he is drinking like a fish. She was like, well, I didn't want to bring that up, but I did ask him the question, like, do you think that somebody with 3 DWIs has an issue with alcohol? I did ask him that. And they objected, because the objection is just relevance. Who cares what you think on that? Unless you're going to forecast the next question, which is, well, you have 3 DWIs. What do you think? You've got to lay the foundation. And it's not that she's dumb, but now we're in Wise County, right? Or Wise or some other county. I should be careful there. We're in Wise or maybe some other county, and the temporary hearing has already been had. So getting the court to go back and say, all right, Justin, now you're here, thank God. Let's just reopen this case after I've already almost heard nothing is the reality. But now these kids are in a tough spot because I was going to DIY. Mm-hmm. And I mean, I tried to DIY my bathroom walls. It took me twice the amount of time, twice the money. So sometimes that DIY needs a little, not the IY.
Mm-hmm. So finally, Justin, if there's one reason people should listen to this podcast today, what would you say that would be?
I mean, I think at the end of the day, what you need to remember in one short thing is you can do it yourself. I want people to do it yourself if you can, but don't waste a minute of trying to do that without doing a consult. Do not do that. It's such an easy part of the process, and I will absolutely steer them if they can go do it themselves, because we're not going to add value.
Right.
So that's my one piece of advice, I guess.
All right. Well, if you would like to get a hold of the Sisemore Law Firm, you can reach Justin and his team at 817-336-4444 or visit lawyerdfw.com. We also invite you to follow the podcast and share it with friends who might find it helpful. Thanks so much for listening, and have a great day.